think, if I recall, he has been a representative on the East African Revenue Authorities Technical Committee. He has been involved in the working groups for the preparation of production sharing agreements. He has been involved in taxation, in the litigation. He has quarreled and argued our tax cases all the way to London and back. He has been in our Supreme Court, our Court of Appeal, our High Court. He has served extensively the country, and he's a lawyer with deep and incredible knowledge. Mr. Julius Caesar Rugaya is also an incredible lawyer. He has battled cases, very many cases in the courts of judicature. He's involved a lot in tax as well. He's involved in the commercial court. He's involved in the civil division of the High Court. He has been at the industrial court. He has been before the electricity disputes tribunal. He has been before the tribunals as long as they exist. And everywhere he goes, he raises dust. And it is the dust, he raises it with fire. Even if you followed him on X and you looked at his various X posts, you would see that he's a man who doesn't hold back. So I am personally honored and privileged to have you gentlemen on, and greetings to you. I'll start with you, Ali. Greetings to you, and hope you're having a fantastic day.
And all the listeners, I'm very happy to be here and honored to share my experience with you guys. Thank you.
And greetings to you, Caesar. Thank you, Ali. Greetings to you, Caesar. How are you?
Greetings, Ellison, and greetings to our listeners. I am quite well. Thank you for the introduction. I don't think I still raise as much dust as I used to. I gave my life to Jesus. I'm now reformed.
Okay, so we'll get right into the conversation, and before I hand over back to Alfred to take us through it, I'll ask the same question to both Ali and Julius. And the question, and I'll start with you, Ali, is just to tell us about yourself. What makes you tick? What made you do law? What makes you passionate? I know Ali is very passionate about football. At one time, he even chaired, I think, a football club, the URA Football Club. They wanted to take the goals and the taxes as well. But I don't know if he still chairs them. But maybe what makes you tick, Ali? What makes you tick, Caesar? What makes you passionate about law? What makes you passionate about the stuff that you do? Just before we get into the more lengthy conversation, if people could just have a feel of the heartbeat and the energy that is Ali Sekatawa and that is Julius Caesar Rugaya. We start with Ali.
I don't know whether I'm tick. I think I will leave that for you to judge what I work with. But just to say that this month I made 20 years in public service. I joined URA in April 2004, University and Law School, URA for 4 years. And then I crossed over this side where I made 28 years now. So I'm a proud civil servant of 20 years. What makes me passionate is, and I've already said this, I'm a public asset, having been, through the born in a public hospital, started on UPE in a public school, USE in a public school, Makerere public government sponsored, and then I joined government to give back what they are giving me throughout my childhood. And I think that gives me a higher, course in what masters also on public money, all the masters you are saying wherever I have been in almost 3 continents on public money. So I have served basically in a way I call it giving back, and I think that is, in my view, a higher cause that I always have in whatever I do, because I believe probably without the taxpayers' money, I wouldn't be where I am. It is also the same passion for sports, because it is my other. And as you know, I held the URA Sports Club for close to 10 years, and we won 3 national trophies before I went and founded the community club called Namtioboyo, which is in the lower leagues. I think that is how humble I am. I am here to share with you. I think this is an interesting topic. Having been the head of litigation in URA for many years, we averagely had between 400 and 500 cases in the system annually, and we resolved probably between 100 to 150 through either alternative dispute resolution or the others through the tax appeal tribunal. And then, having crossed off here with the arguments we've seen, one of the major risks we've been handling is the risk of litigation and how that litigation can affect project execution, and what alternatives we can have to avoid delays arising from case backlog and litigation, so that they do not affect the delivery of the project within the set timeline. So I'm happy to share that experience with you. Thank you very much.
Thank you,
Ali,
for that very clear explanation. You said that you're a taxman. Sorry, you're a taxman.
Humbled, and we are. I want to assure you, Ali, that we are the ones who are humbled to have you here, and we are looking forward to your experiences. Over to you now, Mr. Julius Caesar Rugaya. What makes Mr. Rugaya tick?
Thank you very much, Edison. It's very hard to speak after one of the people that I grew up admiring. When we were young, we used to have some comic books called Super Strikers, and there, 2000s, you may remember them. And every time I meet him, I ask him if he's the same Ali Sekatao that used to be mentioned there. But yeah, quite humbled to be part of this space. And what can I say about myself? I am just a simple man with a simple profile, like they always say. But I think for me, my interaction with the law from the very beginning was both bad and good, and it's the reason why I am here. And it goes back to my childhood days. I hated injustice. And I was never afraid to speak up. I remember one particular incident when I think I was in senior 5, and the teacher comes in class, finds some people making noise, and he takes the entire class out, puts us in the compound and tells us, all of you are going to be punished. And everyone was, quaking, because it was the first week, and it was a new school that I had joined after unceremoniously being advised to leave the seminary, and I listened to advice of my elders. I left. I was never kicked out. I was never discontinued. Anyways, so everyone is, cowering behind whoever is in front of them. And so I look at this teacher, very, very tall man. And I look at him and I ask him why he wants to punish all of us, yet he didn't find all of us shouting. And so he says, all of you, I found noise in class. I said, yeah, you found noise in class, but did you find all of us shouting? Not all of us were shouting, so it would be an injustice to punish some of us for the sins of the others. And he must have thought I was mad. So, of course, I was taken to the disciplinary committee to answer for my transgressions. Of course, I effectively defended myself when I was there, and thankfully, that defense of the other students ended up making everyone get taken back to class. No one was punished. And it earned me the position of the head prefect a few months from that time after that incident. And so I finish, I go to law school. But before going to law school, I have been around town for some time. And one of the things that I did back in the day, I worked on radio. I worked on radio. I am the one who was firing the questions. They are now firing me today. I used to make politicians shake and stammer when they are speaking. Now it's my turn. But so when I was working on radio, a job that I did for about 6 or 7 years, one of the first assignments that I was given was to go to court to report. So I get into court and I look at the faces of the litigants who were there. Old women, children, men looking very helpless. It was a sad situation. And then the judicial officer walks in and it's as if a goddess has walked in. It was a female the first time I was there. And I said, but why? What's this aura about judicial officers that makes everyone get scared in their presence? You feel diminished. But the most annoying thing was that what was happening that day in court was a case of defilement. And this lady, the victim, was in court to testify. And I saw the victim reliving the entire nasty sexual experience. And I was livid. I was not amused at all. Looking at the questions from the defense counsel in cross-examination and the absence of protection from the judicial officer, I said, no, this cannot be, right. Why would someone who has undergone this traumatic experience be made to relive the entire traumatic experience again in court? And people who were in court were laughing. Of course, she would mention some things. And then the judicial officer says, no, mention it as it is. And she says, his animal touched my animal. He said, what animal are you talking about? Anyway, so it was bad. It was a nasty experience. And I said, I am not going to university. I will not. I said I'm not going to the university to do journalism and mass communication, even though I was practicing in that field. I said I'm going to do law so that I can now come back and be a voice to the voiceless. Whether the desire is still the same as it was, or whether now we are following our dear Minister of Finance's words, colleagues, the money will come. Whether we are now following the money, it's a topic for another day. But yeah, that is what drew me to this profession. My absolute hatred for injustice. Whether that makes me tick or not, it's for the public to judge. But yeah, that's all about me for now.
Thank you, Cesar. That's really an amazing journey. I was first going to ask the first question because it's just in here, and he's supposed to speak before you speak. But I realize now you have to speak after him. So with this leave, first ask you first the first question. I see from your biography you have interacted with court for almost 15 years now, both as a journalist and as a lawyer. I've combined them, and you raise dust from wherever courts you go to, as Mr. Elson hinted on that. So I would just want you to help us describe the role of traditional lawyers in what ways you have seen that role begin to evolve as the profession advances. Thank you.
Thank you very much, Alfred. It's very interesting, like politicians say, when they are looking for the answers. But I think we need to start from the legal itself. As we go to the traditional role of lawyers and the evolving nature of the profession, is that we must understand where the legal profession started from. That it's a profession that is deeply rooted in colonial history. and in colonial history where the law was majorly a tool of suppression. It was a tool of suppression as opposed to it being a means of achieving justice. Justice was secondary. The primary role of the law at that time was to, support the powers that be, or that were at that time. So we inherited this imperfect system that was full of what I would call snobbish and aloof land friends, because these are the people who we had seen or who were seen that time. And these are people who only cared about arguments and not justice, and who cared about protecting the ones who were paying them. Like they say, he who pays the piper calls the tune. That justice was secondary. It was never one of the primary roles of the law at the start. But fortunately for us is that even as imperfect as the system was, the system had some things that were a little bit familiar. If you look at some of the doctrines that we inherited from the British, let's say the doctrine of precedent, in highly organized societies and kingdoms like Uganda, the doctrine of precedent was there. You used to hear things like Omsa Mpya. That was the principles, and they would look at what happened in a previous case and marry the facts with that case in order to come to a conclusion. The other thing that maybe was prevalent then is the Audi alteram partem rule. Here the other side, you still hear up to this day things like tosala gwa kawala nga tonawuliriza gwa kalenzi. And so these are things that were here. So however foreign the concept of the law was, it had a few things that were, that were close to home. And these things are the reason why it was easy for our people to get into this profession, but also at the same time distinguish themselves, because it was not purely foreign. Now, the good thing is that the legal profession has its own inbuilt mechanisms, its inbuilt systems that facilitate questioning of the status quo. Now we are going into the evolution. So the questioning of this status quo, when these Africans start to go out to be trained, they are being sponsored by the colonial governments, they reach the other side, they see the standard of living, they see how the law operates, and they realize in the colonial countries, the law is actually made to facilitate access to justice. And yet that was not the case back home. So that's when they come back and they try to create change in different ways. When they're the other side, they stop focusing on the letter of the law and they start focusing on the spirit of the law. And once the spirit of the law possesses you, you cannot just break yourself free from it, because it keeps beckoning, and keeps leading you and showing you what works and what doesn't work. That's what the spirit of the law does, as opposed to the letter of the law. And now, the spirit of the law is the one that has facilitated the changes that we are having today. Because as our societies evolve, so does the law. But sadly, the law is always playing catch up. Now, I think Ellison is the one who has said this before, that the wheels of justice may turn slowly, but they still turn. No matter how slowly they turn, they still turn. No matter how rusty the wheels of justice may be, they can never grind to a halt. And that's because the focus is not on the letter, but on the spirit. Now, just as the proverbial phoenix, the law always rises from the ashes. Every time you think you're burying the law, you're actually planting it. It will always sprout, and it will always bear fruit. As it used to be. Law was war. but it is no longer war. Now it's more collaborative. We have alternative dispute resolution mechanisms, arbitration, conciliation, mediation, plea bargaining, all these coming up to respond to the evolution of society. Now, the law is evolving as society evolves, no matter how slowly. Now, we also have more social justice advocacy today than courtroom battles. You know, we battle on the streets, we battle on social media. You know, people push hashtags and change happens. In fact, sometimes there is more justice in, in the public court, and the public court actually makes the other courts also, you know, I am Catholic, and before we start Mass, there is, when we are confessing our sins, we say, mea culpa, mea maxima culpa. Gunsinze, gunsingide dala. So the court of public opinion has made the normal, you know, traditional court systems beat themselves on the chest and say, good singide dala. And one of the things that these spaces have also brought, and Ellison, I must credit you for this, is that we have created a certain, you know, level of accountability and responsibility and transparency in the delivery of justice by the calls that we make, by the experiences that people come here and share every Wednesday. And I can assure you, the judicial officers who are here on the space, the lawyers who are here on the space, every time we're attending these spaces, we keep saying good sins because we can do better. As the law is evolving, are we evolving with it as lawyers? You know, the other thing that maybe has happened over time is the emerging of emergency of technologies, emerging technologies, you know, exploration of new legal practices, new areas of practice. We have all this being embraced now. We have artificial intelligence. One of our colleagues at office is always throwing ChatGPT in our faces, Grok in our faces. You post a judgment on one of the farm WhatsApp groups, and within actually 2-3 minutes, he has already brought you a summary. And artificial intelligence, one of the decisions that came out some time back, we actually asked if it could criticize the decision. And if you could look at the criticism that Grok brought, you would think it was a lawyer that was seated behind the system and typing in those words. It could see the glaring deficiencies in the judge's reasoning. And so those are all, you know, changes. Legal literacy is also another change, another evolution. We have now taken the law to the public. And I think it's a very beautiful thing that the entire public knows and understands what they're entitled to. The rights that are inherent are not granted by the state. So this, in a nutshell, to me, is how the law has evolved from traditional practice up to the current practices that we have today. Thank you.
Thank you very much, Caesar. Maybe just for the young lawyers on the space, don't worry, AI won't take away your jobs. You can keep trying. But I want to ask Ali a question, and our question is along the lines of, Ali, you've had experience of about 20 years in the public sector, and that is in both tax and the petroleum space now, as you've already highlighted to us. I think people in the space would like to understand, from your experience maybe at URA, where you've mentioned that there is the ADR and then the disputes which are handled at the Tax Appeals Tribunal, how have specialized courts supported access to justice or delivery of justice to people who are affected? And how have they relieved court also of the challenges they're facing in dealing with issues of case backlog and dealing with these disputes that require some level of specialization? Please share with us your experience.
an in-house lawyer's perspective, because I was heading the litigation function at URA, and then of course this side in the Petroleum Authority. The major objective is really to have a quick, trusted, and fast resolution of disputes as and when they arise. Because as you do work, if you're a tax collector, you know that every day you are, it's like rugby, it's a contact sport. That every day you're in contact with the person on the other side, or your officers, or your cars, and so on. Or in terms of assessments, audits, and so on, verification, there's bound to be disagreements. So one of the issues is how quickly can you resolve and have trust in the people you deal with. But I think the law, I think, a civil on. And well, many people are crying of backlog, but some people find it more if they go the other side for different, some lawyers will call it forum shopping and so on. Mera case versus URI took up to the Supreme Court, and one of the major points we are pursuing was that. The second was people were, because the URL law or the tax law say you must pay 30% before you go on dispute. It's, some people have different views about that, but again, it is part of the reason is to have challenges in court, and it was taken to the Supreme Court. But we took a decision and decided to take a case up to the Supreme Court for it to settle the question of whether you can have. And once that decision was made, I think around 2010, 2011, the territory was settled for that you have to go to the tax appeals tribunal first. And what have been the benefits? In my view, the tax appeals tribunal averagely resolves a matter between 6 to 1 year. Of course, you can put plus or minus depending on so many circumstances. But two, it is specialized. So there is an auditor, there is a tax lawyer, there is an accountant, and it also has a provision of saying you bring what you call a layman who gives a proper, lay view. That kind of specialization has meant, at least in my experience, that even when we were at URA, when a decision was made at that level, it was very, maybe 30% would we appeal to the High Court. But also the like Bruce and so on, you will find that again their appeals, even if they have lost, also they are within the 30% range to go to the High Court. And I can tell you, in the 30% that go there, you would find that maybe 15% of them or 10 would be overturned in respect of either side, whether URA has appealed or not. And what two things does it bring? One, it brings the quickness of resolving disputes, but also two, that specialization makes sure that disputes, there's a trusted mechanism within the structure where both taxpayers, tax advisors, the tax authority trust that if the tribunal has made this, you need to think twice before you go. Unlike other, general courts where you find that someone has never actually interacted with a tax dispute or a tax matter, even when you look at his or her CV, at Makerere, she never did tax. When she went to LDC, she did tax for lawyers. For the last 10, 15 years of experience, she has been something else. And then that's the person who is supposed to decide a very technical tax matter like transfer pricing. So one of the things for me personally, I find, and we adjudicated it personally up to the Supreme Court, is the sanctity of that specialized court to make sure that there is predictability, there is quickness, and so on. And probably some of the users right now can testify, because they said I've been away for almost 8 years into another. The second component is the component of the alternative dispute resolution. When we left university, I think they were starting a mediation training and arbitration at the commercial court. I think I was among the first cohort of 4 or 5 people that were trained by KEDA. It used to be called KEDA. And we were being trained, that was the introduction of the alternative dispute resolution mechanism. And I actually mediated some of the cases that came through under that structure. I think it was under Justice Chiragwire, if my memory is correct, and Bamwine, who were the commercial court at that time. And we went and ingrained it also in the URA mechanism. And I can tell you right now, there is a full department for alternative dispute resolution, in that after the objection and appeal mechanism by auditors and so on, URA has established an independent alternative dispute resolution department, where you go as a tax advisor and the URA auditor, and they present before that one and they look for ways. Again, as I said earlier, we resolved close to maybe 30% of the cases through that process. I can say most of, very high level technical cases like transfer pricing and so on. Sometimes the difference is just a matter that you can sit down between auditors and find a resolution. And the tribunal itself put up a mechanism when you go there to say, no, wait, that before we go into litigation, have you done a reconciliation? Can you do this? And you will find that 20-30% of the cases that go through that. And it gives a win-win situation, because many taxpayers don't want to be litigious against the authority and so on. So I think I found that, and I still find that mechanism very important. When I come this side, because this side you're managing a project that has a timeline. We have first oil, the target 2025, maybe plus or minus 2026. But you have a target to deliver. You have close to 3,000 companies that are working, and those companies also have subcontractors, they have workers. Naturally, again, just like rugby sport, you expect disputes. One of the ways we've done here to minimize, again, dispute is encouragement of alternative dispute resolution inside the agreements, mediation, those 3 layers, mediation, arbitration, and if not, you go. And PAU now does more like the 3rd layer if the taxpayer, its contractor disagreed. We are managing there at this level of mediation to make sure that the dispute doesn't spill over and affect. The second is specialized dispute mechanism, which are inbuilt into the agreement, what you call expert determination. So there are disputes where parties have, with encouragement from everyone, that for this dispute, you do not need to go through litigation and so on. this matter can be finalized by an expert determination. You just submit to an expert, and that expert gives you an opinion, and that opinion binds, and you agree that once it is done, you don't have the right of appeal. And why? Because these mechanisms, whereas they will not necessarily oust the jurisdiction of the High Court, they are more trusted because you both agree that we are going to choose Ellison as an independent Jew, or we shall choose an elder who will give us an independent opinion after we presented, and after that, that thing is going to bind us. Again, I have found that mechanism, it has immunized the industry from a lot of litigation, injunctions, and so on. And we have also applied it on the land. As you realize, we've acquired land from over 10,000 people or families. I think 98% of them have been resolved through those escalation layers, up to the level where PAU sits as the last layer between the project and the PAP, and we actually listen to the last points before a matter is taken to the Attorney General and so on. And as a result, you will note that of the PAP issues have gone to the judicial system. So I it's a very telling experience in my view for the last 20 years. And I think it is something that can be copied in terms of enforcement, actually, as we go back to the main issue, enforcement of 142. Because Article 142 makes provision for appointment of specialized judges in situations where there is need and so on and backlog. And these specialized judges can actually be appointed on recommendation of the Judicial Service Commission, but to address a specific need. So if you look at the structure, in my view, under the Constitution, the Tax Appeals Tribunal or a specialized tribunal is one way that relieves this backlog from court. And any other tribunals, as you know, Electricity Tribunal and so on, it's way to relieve because they are specialized. The second is the one of ADR. I think Caesar spoke about it. That applies in any formula because it is commercial, it is voluntary, it is you decide how you dispute. And then there are other mechanisms, Ellison, under the law, like the CADI courts and so on, but also the invocation of 142. For example, if the major disputes in the commercial court relate to construction, there is nothing that stops the president from appointing specialized construction lawyers to handle those disputes for a period of 6 months, in my view. And borrowing on this experience, I think it would help reduce backlog in the judicial system. I think maybe I could stop there and allow Caesar and so on to proceed from that point.
Thank you.
Thank you.
Thank you so much, Ali. And I think that
just before we go back to Caesar, I think for many people who are listening, you talked about Article 142.2, and for those who don't know, on this space we've been making the case that our Constitution provides that where the office of a judge is vacant, where he's unable or she is unable for some reason to perform his or her duties, and where the business of the court so requires, then the Constitution allows for judicial officers to be appointed on a temporary basis for a specific purpose, and we are calling them mission-based judges. These are people who come in to replenish the judiciary, and the Constitution says whoever is qualified. Now, Ali, I wanted to, before I pick you more on the issue of mission-based judges, I want you have spoken of the Tax Appeals Tribunal, and I think many people who are listening don't understand the structure of the Tax Appeals Tribunal, the role that lawyers, particularly lawyers, play in the adjudication of the disputes in the Tax Appeals Tribunal, and the model of experts sitting, because you've given us incredible statistics, and you've told us that there's a body where taxpayers and the tax body go, and where disputes are resolved pretty quickly. I mean, just think about, if you resolve, we've been saying this on the space, if you resolve the dispute within 1 year in the court system, unfortunately, that would be prima facie evidence of corruption. Now, we have in Uganda a tribunal that is resolving matters, you've told us, between 6 months to 1 year. So if you could just tell us, first of all, the structure, the makeup, what happens there, and then the magic of that tribunal, before we run to Caesar.
And actually, one of the questions we were arguing in the Supreme Court is whether that Article 152, comparing it to the article creating the High Court, the courts of judicature, because the other argument was that the courts of judicature and the High Court remain with its original jurisdiction. But we successfully argued in the Supreme Court, and they said, yes, there is this article, but this article specifically creates specialized courts and actually consistent with the Constitution. So that law, there is a Tax Appeals Tribunal Act that says that within a 7 days, once a taxation decision is made by URA, you're free to appeal to the Tax Appeals Tribunal. It has very low filing rates. They are not the ones like the ones in the High Court, which are based on subject matter. It is a flat rate. I think my memory 10 or so years, it was 20,000. But I see Bruce here, who is a daily practitioner there. He can confirm, but it is a flat rate. It's very permanent members, and actually some of the members are practicing advocates. Formerly, the chair was Dr. Asa Mugenyi, who has eventually been appointed to the High Court. Now it's being chaired by formerly from PwC. So it has different professions. It has an auditor, it has an accountant, it has a tax practitioner, it also has an ordinary person. And its quorum are usually 3. They are the ones that make. Ideally, it is supposed to be informal. It allows representation, even from accountants, from auditors, even from the actual taxpayer. And the other side, the permanent side opposite, is URA, and is independent from URA. It makes decisions that bind URA. They are not advisory. The way it is structured is supposed really to make it there, and the main issue is really to try they follow the substance. Is this part tax assessment correct or not? And it's been a very successful example because its turnover compared to the judiciary is high. And I can tell you the appeals of law to the High Court and then the Court of Appeal. But I can tell you when you look at the statistics, only close to 30%, because many people want case to management for you on why you should appeal. And then over time, if you look at how many appeals have been made from the Tax Appeals Tribunal, and then over time, they are really which means and which has sent a clear message that these guys know what they are doing. Before you appeal, you must assess. And I think it's a very good example of a successful specialized tribunal. And when we are arguing the Supreme Court, we have to go out to many countries in the Commonwealth and get examples. South Africa, Zambia, Ghana, very successful cases on how it has operated, but also to show that where tax matters have been left in the open judiciary, the answers have been very disastrous. Many of you here at DC, many of you will qualify to be judges of the High Court, but you can honestly ask yourself in your 10 or 15 years, how many tax matters you've interacted with. And therefore, if you are now the person to decide how much special into that, compared to if they brought a retired accountant. I've heard the name Akapwai, like a retired former commissioner general. Mr. Akapwai was there for many years. I hope the person here is not from that line. But they pick a person of that quality and bring him, and he has practiced tax before the commissioner general for 20 years. And therefore, it is very easy for a taxpayer to follow his advice and say, okay, if Mr. Akapwai says I should, you are wrong. Very. I told the commissioner general that, Mr. Akapwai has said we are wrong here. It is given a lot of weight. It is along that line. Thank you.
Thank you.
Thank you.
Thank you, Ali.
And I think that's a fantastic explanation. We're seeing an ad hoc judges, lawyers serving as ad hoc judges with other professionals, running their practice, sitting down, hearing matters, removing backlog. The example is right before our faces. And maybe I can hand over to you, Alf, to shoot the next question to Caesar. But Caesar, I have a comment from Angelo Izama, which I'll be reading for you later on. And but I think the conversation and the point Ali is making, I think, cannot be overemphasized. That specialization, skill, creativity in dispute resolution are exactly what we need to make sure that we put justice back, that we put the courts back into the business of justice. Over to you, Alf.
We're going to the back of judges and probably judges. I saw as this has been a very good picture of how the lobbying, more collaborative. Jara now is becoming more like the major dispute resolution, and now the traditional litigation is always becoming the alternative one. And so when you're painting that picture, I couldn't help but wonder whether our traditional lawyers are evolving with the law, or they are now the ones playing catch up with the evolving law. And when Mr. Harry commented on the legal training that trains the tax lawyers in court, I wondered. So from your perspective as a practicing lawyer, what additional skills or approaches do young lawyers need to keep up with the evolving profession? And I would like you to focus on those skills which were not necessarily taught at law schools, which they need to really adopt or embrace so that they are not left out. They are not replaced, like how Mercy was fearing that they may be replaced by AI. Thank you.
Thank you very much, Alfred. Just before I answer Alfred, I'd like to draw me back to the media profession. He will not succeed.
No. I'll read it for you.
All right. Alfred, have lawyers responded to the evolution? Are lawyers evolving? What is changed, leaving them behind? Can they fight against the changes, the evolution that is happening? Do they have the ammunition? Do they have the power? Are they, competent to even face this elephant of evolution of the law? Are they playing catch up or they are moving with it? Very, very interesting questions. You cannot fight development. And whether you like it or not, if you resist change, change will always change you. There's just little that you can do. We are not, and of course I mean positive change. If you give in to negative change, it can also take you. But how are lawyers, responding? How should they respond? Especially young lawyers, a cluster that I know you're really very passionate about, and you've tried to mentor as much as you could, to your credit. We must adapt. We must adapt to the changes in the legal profession, to the changes in the way justice has been, delivered. And in adapting, we must even go back to some of the ways through which justice used to be delivered back in the day. When I'm making a case for mission-based judges, some people probably feel that this idea is, coming from heaven, that Ellison was seated there and then he had a voice from God in a baritone. My beloved son Ellison, mission-based judges. These things have been there for a very long period of time. And one of the ways through which mission-based justice used to take place, for those of us who grew up in the villages, we knew there are people in the villages whose word was final. When you had committed crimes, we even used to have them settling cases that ordinarily would have gone to the normal, courts, and they would sit there, and whatever they would order, it would have to be done, because the consequences were there. These were systems that were not legalistic in nature, but they were working. And so as the law evolves, we have seen that when we changed and we made it more commercial leaning than justice leaning, the law started becoming a problem. Instead of becoming a shield or a sword, it became a double-headed viper. That as you think you're attacking the other person with one head, the other head of the viper is also poisoning you. So, am I being heard now? Sorry, I just had a small network challenge. And so the evolution of the law, the evolution of the delivery of justice was in the sense that if you thought that things are going to remain as they used to be, then you are going to be left behind. If you thought that because, like I said, the law stopped being a shield and a sword and it started becoming a double-headed viper. A double-headed viper in the sense that when one head of the viper is attacking your enemy, what you're not aware of is that the second head is also poisoning you. Now that's what happens when you resist change and when you go, to things that don't matter. So we must adapt. We must go back, do some introspection and go back to how things used to be, because they were okay then until we made it more commercial leaning than justice leaning. We must embrace technology. Young lawyers must embrace technology. You can't avoid it. You can't sidestep it. You can't wish it away. The technological advances that we are having right now are just too big to be fought by anyone. And I think you've seen the way the legal practice has changed. We are not allowed to advertise. But lawyers do some indirect advertising that unless you're sharp, you may not even understand. Nowadays, a judgment is issued, and within 5 minutes, you have legal alerts, running left, right, and center on all social media. And I can assure you, these lawyers who send out these legal alerts are being, noticed. Now, that's how they are evolving with the law, by using technology to make sure that now justice and delivery of justice is much quicker and faster. We've seen tools like Yuli.
being developed, and now you can sit in your office and you'll have access to all the cases that you would want. Yet back in the day when Ellison had started practicing and Ali Sekatawa, they had to go to High Court, library and sit, and now you have everything on your fingertips. But also the most important thing is that we must change our business models. We must change our business models. Lawyers can no longer afford to sit in their offices and wait for clients to find them there. If you do that, you're in for a rude surprise. The changes are going to leave you, where you are. You now have to go to clients. You now have to do client management. Now we have WhatsApp groups for clients, where clients can even send all manner of insults. But you have to remain calm, because at the end of the day, colleagues, the money has to come. So there are very many ways through which we can really adapt and move with the changing times. And those are just some of them. Thank you.
Thank you, Caesar, for giving us that business strategy meeting. I think this has become a business strategy meeting as well. For all law partners on the call, I think you've taken some good notes. Mr. Ali, I'd like to ask you one question along the lines of arbitration. In your experience of over 20 years, you've either been part of an arbitration panel or you've appeared before one. And my question is, in your experience in appearing or being part of these arbitration panels, how, because it's definitely very different from appearing before a formal judge, and how has that difference in that experience made either a case for appointment of mission-based judges, because obviously it could be slightly informal setup? Does it make a better case for judges or not? Thank you.
Arbitration. Uganda, you remember the heritage arbitrations, then the ones that were brought by, and then there are those for Arabia against the Republic, international, all of them held in the US, appearing either an expert or as a witness, as an officer. I've also had the privilege of appearing here, as I said earlier, arbitrations under KEDA in the early days of my career. I can share in my once. So very, very specialized. The choice of those arbitrators club worldwide. In the specific areas they work in, and as you know, that relate to international circumstances, like maybe fraud and so on. But what I've seen is that when you say the London Court of Arbitration, CSA, the International Court of the one under the World Bank, and therefore they give each party, despite the disagreement, the finality of a dispute. And you know, it's very involved and so on. If you look, see many of them against Argentina, Venezuela, and so on, you will find a what so on. And therefore, either the witness or the tribunal itself is very special, but it gives you as a litigant finality. When you lose, you win. And actually, one of the reasons for the backlog here, you will, in the judicial system, see if they give you a judgment, there's always a certain level of, I mean, determine, even you as an advisor, say, no, I don't think we need to appeal this, let's leave it. So that level, to that extent, I agree. It's the same with some of the arbitrations I've been involved in here, locally, especially commercial or construction disputes. And when they bring specialized people, someone from the region, that body for engineers registration board, or most times those very retired, senior citizens. Many times their awards are respected. Many times attempts to have them set aside have not been very successful. I think one of the famous cases that have been in the judicial system that started at arbitration is the Alcoa Workers' House, and I think the last I think was restating decision of the arbitrators, if I didn't get it. It is because speed and the level at which they go this, I think it makes sense to educate. International arbitration, because of the money, I think there is now a that it is making, and sometimes they delay because you can go for arbitration for UK, it's still subject to all these preliminary issues. So there's that other debate. However, the crisis that we have in our country, in terms the time to think out of now, and the example, or even the Chief Justice, that if you really invoked the provision, which in my view clear, when you read them, they are very clear, the situations there, they are clear. So if the judiciary invoked that, the Judicial Service Commission, and then used these other alternative specialized the arbitration on how they choose, or specialized on how they choose. If it's a purely land dispute, okay, you get a lawyer that has been practicing land for the last former commissioner's land administration and so on. They are there, some of them are retired, but so on, and you put them on the land dispute. If it is insurance, in the heads of insurance institutions, heads of legal or insurance company, if it's banking, you follow that. If it is tax, so you group, then you invoke 142, specialized judge, be able to do away with this backlog problem once and for all, even at appeal. So if you did it at High Court and there are appeals, depending on seniority, you again get the same quality of people. They are around town, I can tell you. I've met very many Ugandans formerly working in World Bank, IMF, so many very specialized people, very reputable people. and specialized. So if you grouped the dispute in that manner, I'm very sure there is a solution that is well precedented that can address this. And secondly, it is not new, I think, here. It is part of the Commonwealth system. All you need to do is start from our grandfather, because we get this judicial system, I think, as Caesar said, it's part of the colonial, legacy. If you look at our colonial masters from the UK and all the other civilized countries, you will find the very common feature of their judicial system. What is not common is that you have a case and it is in the system for 12 years. I had a case when I was in URA, personally filed by myself, and it went to the Constitutional Court, and I and my lawyer forgot about it, a constitutional petition, until I was working after 12 years, and one of the clerks told me, like 2-3 years, that they gave a judgment in your matter. Good enough, it had been decided in my favor, but I had forgotten about it. The constitutional question that had been raised maybe 12 years was completely irrelevant today. I think you can avoid that by doing that. If it's a constitutional matter, you have people like Mr. Waruguru, who has been in the Constitutional Court, I think, from time immemorial. So if you have backlog on constitutional matters, if you really got Mr. Waruguru and took him to Kalangala and gave him 50 cases and you ask lawyers to appear before him, I think he would give you very good constitutional judgments with a panel of other eminent lawyers, and they will be able to resolve those constitutional questions. Then you can say, let the Supreme Court handle the appeals that are rising from this panel. I think it's a precedented thing, and it's a very noble idea, and I commend Ellison and your team for advocating for this.
Thank you, Ali. I am very happy that you are supporting our idea, but I am very amused that the constitutional question you asked was resolved after 12 years. You had forgotten about it, you had moved on with your life, and the constitutional question was no longer relevant. But maybe let me hand over to Alf to ask the next question.
Yeah. Thank you so much, Mr. Ali. First, I would first like to recognize the presence of Mr. Isaac Samaka, the President ULS, Dr. Heri Karuhanga, Council Katompanga from UK, Sir Nicholas Opio, and several judicial officers who are on call. Thank you for always joining us on this conversation which are shaping the future of the legal profession. We're always very humbled with your presence and for sparing your time to be with us. Now, from Mr. Harley, from your submissions, we can all agree that lawyers can no longer afford to be just courtroom advocates. Traditional is dying slowly. So from your experience, which is spanning 2 decades in public office, I mean, these 2 decades, I think started practice where some of us were like in primary, we never knew that we would be lawyers. But from your experience, which is spanning 2 decades, I would like us to maybe guide us on how can the profession better prepare lawyers to serve not only as advocates in private practice, but as in-house counsel. This is a role you have done for now like 2 decades, as adjudicators, as mediators, as arbitrators, as researchers for the judge, as company secretaries, and as corporate governance professionals. Because you realize probably when you were at law school, we are so much trained for this traditional lawyering of courtroom advocacy, but yet you come out of law school and there is much to do besides this traditional advocacy, which is now in regard to in-house counsel, adjudicators, mediators, arbitrators, researchers, company secretaries, corporate governance professionals, and you have been really hitting on all these career routes in your submissions. So just to guide us, how can the profession better prepare lawyers to serve in those capacities? Thank you.
Thank you. look and sound very old. I consider myself part of the youth. So don't make me feel very, 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 very old.
We are the young lawyers. Me and you are the young lawyers.
I've never left it. So, so besides that, I think from my experience, personally, I worked here. I worked in URA. I was head of the investigation during the UNRWA Commission, so I did the restructuring on UNRWA Commission of Inquiry. I've done a few areas in government. I think one of the maybe tips personally I can share is not to be a jack of all trades. I think one thing I have seen is that either by opportunity and so on, to find that you are everywhere. You are, because they're very wide. If you did a space here on the law relating to ICT and AI, I would just sign in to listen, just like any other senior 6 student, because my knowledge of that law or whatever relates to that is only to the extent that I interacted with the computer and ICT and so on as a support tool, but I have not done a law in that area. But I have probably, I said I've spent maybe 10 or 12 years looking at tax and oil, and therefore I decided, okay, this is what I know. I think one advice I can say is specialization, is choose maybe 3 or 4 areas and go deep into them. Deep as you can, you can go. 2 is don't stop learning. Do not stop learning. I think you say I am 20 years. I probably have maybe tax cases with my name, maybe close to 400 to 500. But somewhere I went for a master's degree, maybe a 3rd master's degree, and the lecturer asked me, you should be here teaching. And I said, no, I think I can learn a few things from here based on my experience. So the second is that do not stop learning. I think one of the big examples we have is forget the political issues and so on, but Robert Mugabe. Robert Mugabe, I think by the time he died, he had 7 degrees, and none of them was honorary, like the National Council put. None of it was. Every degree he had gone to class and studied it. So again, in my view, do not stop learning. If you go internationally, like in the US, you will find that law degree. They do not allow you to join law school as a first. They say or engineering, then you do law as a second. I think it's a very good experience, because then if you went to medical school and you came and did law, you are most likely going to be a good, medical lawyer. The same if you did accountancy first and then you came and did law, it's most likely that you will be, like we met people, colleagues here like Akena and so on, who first did accountants and then crossed over. You will find that their appreciation of tax is different. If you went to engineering, the same. And I've seen people who have done reverse. I have friends that did law and then went back and did an ICT degree, or even a medical degree, or an engineering degree. And that mix has made them, whether he sits on the bar or is advising in the construction industry, I think he is in much far better advantage than is to not stop learning, to not, try to learn as much as possible. But the third now, again, is that we are no longer operating in a localized environment. You know, we are working, for example, on the EAC. Whether you want it or not, we have integrated with Tanzania, with Rwanda, with Burundi, with all these other countries in the region, DRC, South Sudan, and Somalia. I think if you're studying or specializing in something or doing connection, please don't be localized. Do not leave law school and you concentrate to Evander. If Ellison has mapped out his zone in Arua, you are also going to Arua. I think there are opportunities. I've been to South Sudan. There are people there. They are surviving. The South Sudanese respect Ugandan lawyers because most of them have studied here, KIU and so on. And therefore, you don't need to, fight for space around. You can go to Kinshasa. You can specialize what is in Kinshasa, what is in Kenya. So in my view, the third item I would say is make sure that when you're specializing, let's look at the regional and opportunities. Let's not just look at here. We look, please take interest in what is happening around. Unfortunately, in law school, they don't teach us about, business. We are not taught business. I had a friend who I studied with here. He studied medicine, and then he went to the US and started their medical school. So when I went to visit, I asked him what are and they made him repeat the whole course. I asked him what are the major things you learn here that are different from our side. One thing I found, like in the US, is that 30% of their school curriculum is to teach you medicine as a business. Medicine as a business, not as a service. Here, they teach medicine to save the humanity. It is a business. Our courses in law school, all of them, they teach you to litigate, to do all, but I don't think any of us have sat and we have special lessons in class of law as a business. So I think that as we look out in the world, we must look at the legal practice as a business and how it relates to the environment. If we are now looking at infrastructure, oil and gas, we are looking at energy, you're looking at SGR, you're looking at PDM, you're looking at all these other programs that are happening around the country. How does the law come in as a business? Again, my advice is, if you're looking or practicing and so on, I think that's the other aspect that you need to look at. But again, who am I? I'm just a public servant. I've also not crossed over the other side. But these are the few areas that I think, in my experience, I can advise. On condition that your next question, you call me a youth, please.
Okay, younger lawyer early. You can proceed.
And I think Ali raises a important question, but I want us to go back to 142. You forgive me. I can see your.
I want us first to walk back into 142.2. And I want you to give us your view on Article 142.2. For those who are just joining us, first of all, you're very welcome on this space. We have a few minutes to go and we will be winding up soon. But thank you so much for joining us. We are having a discussion which are reflections from the front line with people who have been in battle in our legal and judicial space. And now my question to you, Caesar, is quite simply your view on Article 142.2 and incorporate it with these, because I've received these two questions as well for you. What is the legal or policy case for appointing seasoned judges as what we are calling mission-based judges. And in the current structure of the judiciary, is there space for the sort of judicial officers that we are proposing? Now, for those who don't know, 142.2 of the Constitution of Uganda has 142A, B, and C, and it provides for how judicial officers are appointed. And it provides that where the just office of a judicial officer, that is of the superior courts, the Supreme Court, Court of Appeal, and High Court, is vacant, or where for some reason a judicial officer is unable to perform their functions, or where the business of the court so requires, the President, acting on the advice of the Judicial Service Commission, can appoint judicial officers on a temporary basis for a limited purpose, to come in and fill in those gaps or to carry the load where the business of the court so requires. Caesar, is there a case for the appointment of, we've never done it in Uganda before, in terms of appointing lawyers. We have done it, I think the Supreme Court has quite extensively done it in the past, in terms of appointing judges from the lower courts to come and sit on the Supreme Court when they don't have quorum for certain matters. So in the, I think there are a number of Supreme Court decisions which were made. I think the decision of Henry Tumukunde, the decision of General David Tinyefuza, as he then was, a number of decisions in the Supreme Court were made by judges who were actually not Supreme Court judges. They were brought from the lower court onto the Supreme Court. The same thing with the Constitutional Court. There have been instances where judges were brought from the High Court. So you've got judges like Justice, I think, Ogola has ever sat, I think Justice Bamwine has ever sat, Justice Egwenda Ntende has ever sat in the Supreme Court without ever being appointed to those courts. So for those who are joining, that is the constitutional basis of 142.2. And Caesar, I want you to just tell us whether there is space in the current judicial structure for these sort of judges, and do you support the idea, and if you do, or if you don't, what is the legal and policy case for it?
Thank you very much, Edison. I think the starting point should be where we are now. Where we are now is that we have a problem of case backlog. This problem of case backlog was created by none other than ourselves. We are the ones that have created it over time. But it is also incumbent upon us to be the ones to provide solutions to the problem.
We cannot have solutions, we cannot create solutions at the same level of thinking that we were at when we created this very problem. So, in as much as case backlog remains a septic wound in the delivery of justice, we must come up with solutions that are workable and that are reasonable. To treat this sepsis, we need a multi-pronged approach. We need to support the judiciary's immune system. We need to administer antibiotics. We need to conduct surgery, radical surgery of the entire justice system in order for us to deal with the problems that are affecting delivery of justice. It cannot remain business as usual, because it became business unusual very many years ago. It became business as usual from the moment litigants started waiting for years to get judgments and even dying before they get their judgments. It became business unusual from the moment lawyers started filing frivolous cases, because we are partly part of the problem. I don't know, for the lawyers on the space, when was the last time you had a matter dismissed on no cause of action? I have not had one dismissed in a while. There are always tribal issues. Whether the tribal issues are reasonable tribal issues is another question. I mean, it's the discretion of the judicial officer. But yes, we also have that problem. It became business unusual from the moment judicial officers started going absent without notice, without official leave. You go to court. Sometime back I went up country after driving hundreds of kilometers. A matter had been fixed the previous day. It was fixed on Monday for Tuesday. I drove Transnight, reached that up country station the following morning, and I phoned the judicial officer was not there. and the clerk told me the judicial officer had taken the child for soccer practice. Now, it became business unusual the moment we started having judicial officers who act like demigods and are no longer part and parcel of the resolution process in our judiciary. And so, this is why we are making a case for mission-based judges. Why? Why do we need to get these lawyers to fill in these positions on an ad hoc basis, on a temporary basis? One is that it is constitutional. It is provided for under the Constitution. The lawyers that we are talking about are experienced in their fields of practice. They are competent. They are specialized. They have holy anger, that desire to see change, because they have seen the messes that have happened. You know, they have seen the cries of their clients. They have heard the cries. They have seen the tears. But also it is a very cost-effective way if we go under Article 142, Clause 2. But also, even for the lawyers themselves, is that eventually you end up gaining even more experience. Once you sit on the bench, then you become a better lawyer, because now you know if it may be permitted to use the word nonsense, the nonsense that some lawyers were submitting before you, now you know. So you cannot go back and you start submitting the same. And so Article 142, Clause 2 is a game changer. It is the grease that can oil the wheels of justice so that they can turn faster. Article 142, Clause 2 is maybe, we can even equate it to wings that would enable the delivery of justice to start flying. Once again, it is the thrust that will push this plane to take off. Article 142, Clause 2's operationalization is not just long overdue, but we needed it as early as 1995. The framers of the 1995 Constitution were very smart. They knew, they foresaw challenges. They knew that there would be a need. There would be a case. There would be a desire. The business of the court would so require for the appointment of mission-based judges. Now, the business of court has required, it has desired the appointment of mission-based judges. The desires of justice have been ignored since 1995. The need for justice is crying in the wilderness. It is looking for that one person to give it just one drop of water so that it can breathe again. Ellison has not just brought one drop, has brought an entire ocean of water. Okay, not ocean. Ocean water is salty. Fresh water from Lake Victoria. You know, to quench its thirst, justice is no longer begging and beseeching for mission-based judges. Justice is now demanding. It's a demand. It's no longer, you know, a helpless cry for help. It's no longer a helpless call in distress. It's now a demand. It is demanding that we listen. And we operationalize Article 142, Clause 2 of the Constitution. It is about time we listened and did, as the framers of the Constitution in 1995 decided in their infinite wisdom. Is there a space for mission-based judges? Yes, there is. Unfortunately, the space is only in one limb of the judiciary, because we have the subordinate courts and we also have the upper bench. From High Court to Court of Appeal to the Supreme Court, mission-based judges are provided for under Article 142. Unfortunately, at the magistrates court level, we do not have that equivalent. And yet we also have case backlog that is, you know, emanating from these magistrates courts. Magistrates courts, where some of the magistrates that are being appointed right now do not even have barely 5 years, minimum surely 5 years in practice. Someone has never won any case, not even a temporary injunction, not even an administrative interim injunction that is ex parte. Do you know what it means for you to lose an ex parte application? But you find without any record, you know, of successful legal career, you're now going the other side and you're sitting in the judgment seat to adjudicate cases. It is the reason why we are having decisions where leave to appeal is granted when it has not been prayed for, when it has not been applied for, where we are having a one-page ruling without an analysis of facts, without interpretation of the law, without even marrying the facts and the law with previous, judicial decisions. It is the reason why we are having cases that are being decided in total ignorance of established legal principles. But also, it is one of the reasons why we're having delivery of justice being done in such a mechanical way that it is no longer humane at all. We stopped focusing on the people, the subjects of justice. We just look at them as statistics. When we are mentioning the amount of money that is being tied in the commercial court, when we are talking about the number of years that people are spending on remand, we are looking at all these as mere statistics. We were no longer focusing on them as human beings that deserve to be treated with dignity, with respect, and to be accorded the ultimate protection that the framers of the Constitution provided for them under Article 142, Clause 2 of the Constitution. So it's about time. Thank you, Ellison.
Thank you.
Thank you, Caesar. And I think you have really banged that table extremely well. But allow me to ask the same question to Ali. What's your take on Article 142.2?
Earlier is that I actually find it because it creates a limb the JSC, Supreme Court or Court of Appeal. So I think it's what you call given to the JSC. So unless the so that the defeat requires a special but also getting more judges. I think this second route, I am not aware that either the chief invoke it and has said no, or there is either an opinion or something that is said. But in my view, the tests are, and that determination is I think maybe the first step that is affected by this. The persons that are supposed to be is required under the second leg to make sure that they meet the minimum grade for appointment as judges of the High Court, Court of Appeals. Because I'm aware that when the GSC sits, usually for appointments, they send more names. check and so on before they appoint the 10. It then commission or the highest office of this land has more people that have been judged. So it's just a matter of, sending this and requiring pool of the people that has been forwarded before. Now this time probably based on my earlier submission or the nature of the is even if also allows people who are above supposed to invoke it, supposed to be moved because that mechanism on decision as head integrity the broader appointing mission judges since they are just assignment, they maintain in the constitutional court on the appointment.
Of up to 5 years. Seriously, we have bigger problems in the judiciary. and especially in the upper bench. So I thought that that should not go unquestioned. Thank you.
Yes. Thank you, Mahat. I think that was a straightforward question. Caesar, the idea is that we should not get keep. We should democratize the bench. I don't know what you have to say about that in 1 minute.
Thank you very much, Ellison, and thank you, Mahad. Not getting is the reason why we are here. It is the reason why we have case backlog. But that will be a debate for another day. Competence can be judged in different ways. The challenge is what are the competencies that are looked at before some of these colleagues of ours are appointed and they leave the band and they get to the bench. But also seeing that time is going, I don't know if there's another question or I can my parting shots and I run away before my wife locks me out of No, he's free to ask. He's free to ask. Oh, no, I don't have a wife also, so no, I'm just kidding.
No, I just want to say thank you very much to Mr. Ali Sekatawa, and I want to thank you so much, Mr. Julius Caesar Rugaya. I think we've benefited a lot from your wealth of knowledge and experience, and anyone who has attended this space would definitely testify to that. I'd like to just invite you to give us your parting shots in 1 to 2 minutes, and maybe we can start with Mr. Ali Sekatawa, and then we'll go to you, Caesar. Thank you.
Guys, to join me comment. As you know, we had so many people that who sabotage our projects, and I would like to, on behalf of the oil and gas industry, standing up at the right time. All industry was under attack, and to say so many other people here. We stand in solidarity on the issue being for cleaning up the backlog and the judiciary and so on, and this has been a very good discussion. Probably to correct, I think I've been corrected. See, the Alcon case, the award was vacated, but I'm the one that made reference stop the point I was trying to make that these arbitration award circumstances are they it is correct the Alcon award fell in those circumstances, but generally as a model it's a very good specialized mode for purposes of invoking 140 move the Chief Justice, the ex-plat, move the Chief Justice formally to invoke one. See the first set of judges being appointed, specialized to help us reduce the backlog on the ease of doing business. There is a report and one of the key they assess was a time when we had a team of Justice Chiragwire, Justice Bamwi, Islamic Mukasa. That team when the Egode improved based on the of commercial court cases at the commercial court, and because it's border post for other service providers and so on. But the commercial point of disposal, big max, and when the spent in resolution of dispute, and we are ranked lower. So the cause, I think, here should cause, because once that area is higher, and therefore FDI, and that is my character. Thank you.
Thank you, Councillor Ali. Just LOB, someone asked that he understands your love for football. So what's your prediction, Arsenal versus PSG as we head to the match? Who is winning today?
Okay, let will overcome.
Let's wait and see.
Thank you very much, Mr. Allison. Powerful, and it's a call to all the people in the space and individuals who open their minds and hearts to practicing in different spaces. I'd like to invite
very much, Mercy. Thank you so much, Mr. Ali Sekatawa, for your insightful contribution to the entire legal profession and for over these years and to this space as well. I have personally learned a lot from you, as I always do every time you speak. Thank you, Ellison, for keeping these conversations going since last year up to today. You have proved yourself worthy to be elected by Uganda Law Society members to go and represent them on the Judicial Service Commission. And I can assure whoever is on this space, and even those who are not on this space, I know the message is going to reach them. Ellison is the right man for the job. He is the only one that has provided workable solutions from last year up to this year. And he has consistently and continuously enabled us to see the things that we had hitherto not even bothered to pay attention to. So thank you so much, Ellison. My parting shots, as lawyers, it is not sufficient to have great qualities if we cannot make proper use of them. It is not sufficient to have knowledge. It is not sufficient to have all this experience if we cannot make proper use of it. This is the reason why we need to be deployed as mission-based judges. Our call to the powers that be is simple. Deploy us, and we show you what we are capable of doing. Deploy us, and you deal with case backlog once and for all. Ellison Karuhanga has shown you that it's possible. From the various people that have come on this space from different jurisdictions where this solution is working wonders and magic, we also want the wonders and magic here. And maybe after serving on, on a few missions, we might give some of you honorary doctorates, the ones that will be recognized by National Council for Higher Education. I thank you, colleagues.
Thank you everyone who has joined us. I know people have somewhere to be shortly. I'm very grateful to Caesar and to Ali
for a very valuable conversation, for giving us examples, for showing that what we are proposing is not controversial, and for really talking about the length, the breadth, and the depth of dispute resolution in Uganda and of serving the people of Uganda. I salute Ali for his service to the country that he has clearly elaborated, for coming here at extremely short notice to both Ali and Caesar. I again use the opportunity once again to send condolences to the Ruparilia family, a client of ours, of mine, who has endured an incredibly terrible tragedy. I greet everyone who is on the space, and I think ultimately we are discussing serious issues. We are discussing serious issues because this justice system does not exist to serve itself. It does not exist to serve those of us who work in it. It exists to serve the wider public. The judicial power under the 1995 Constitution is derived from the people and is exercised in accordance with the wishes, norms, and aspirations of the people. It cannot be the wish of the people, as Ali Sekatawa has told us, that you file a constitutional petition. The constitutional issue becomes moot. 12 years later, as you are minding your business, you are told that your judgment has come out, and you're asking which judgment. And you are told you filed a petition, and you're saying when, and it is 12 years ago. The Constitution provides that constitutional cases shall have priority. If the priority is 12 years dispute resolution, then what about those who are fighting for land? What about those who are fighting for property? What about widows who are thrown out of their homes? We need to make our justice system accessible to the people. It must be a justice system that serves the people. And we must also acknowledge that a lot of work has been done, as Ali pointed out, appointment of judges, rolling out of ICT, ECMIS and things like that, but we need to do more, and mission-based judges is one of the ideas that we can come up with. I could speak forever, but allow me to thank everyone who has joined, as we always say in these spaces. Good morning, good afternoon, good evening, and good night. And to the members of the Uganda Law Society, the song we'd always propose to sing for you as we end this show is the same we sang last week and the same we are singing now. Because after you have been able to ensure that nobody has stopped reggae, the next question that the Law Society would ask itself, because I can assure you, nobody is going to stop reggae. But after nobody stops reggae, when that time comes, the question, colleagues and friends, we shall ask ourselves is that wonderful Afrigo question. Oli mujara, musaja singanze.